right, so the parties for the other matter can come back, please. Okay, so Mr. Smith, this is your motion?
Yes, Your Honor, I'm making a motion to stay the garnishment order that was signed on June 24th and I received on July 8th at 3:09 p.m. I have no money to garnish. I'm actually currently in debt $27,782 between a TD Visa and line of credit. This garnishment order, they have taken about $1,700 from my 3 bank accounts, which is now limiting my ability to just do everyday banking. And I have no money to garnish to satisfy their order. And but all this is doing is stopping my ability to conduct day-to-day banking, which, as you can imagine, is causing me a great deal of distress. I am currently working on an appeal to the Supreme Court of Canada, which I have until August 20th to file. And I'm just simply asking for a stay order on this garnishment notice until such time that either...
I don't think I can stay it because it's just a support order, right?
No, Your Honor. This I have been making my child support payments except for the month of August because all my money has been garnished. This is a garnishment order in regards to costs from our trial. I have been making my child support, and in fact I have been overpaying that. And again, though I have not made August, but I am quite a bit overpaid, so I'm sure it'll all equal out. I'm waiting to hear back from FRO in regards to that. This garnishment order is in regards to the cost order from the trial, but as I stated, I have
what was the amount of costs ordered at the trial?
Your Honor, if I can jump in, the costs of the trial were in the neighborhood of about $62,000, and then there's costs of the appeal, which is north of $7,000 now, which has been paid. But I don't know if I might be allowed to interject just to explain why you don't have any material from my client.
Okay, well, I'll actually let Mr. Smith finish if there's anything further he wants to say first. So, Mr. Smith, I did look up the trial decision, and I did look up, I guess I didn't see the cost part of it, but I did see the Court of Appeal decision that prevented perfecting your appeal.
Yes, Your Honor.
Right.
I with the appeal, I ran into a lot of technical problems as everything is digital. And the requirement of Adobe software and adding bookmarks and whatnot, and I ran into some problems that my factum was too big, and the Court of Appeal had sent me a couple of emails I didn't receive. I finally was notified about a week and a half later. Ms. Harris made me an offer to complete a factum of 30 pages by a certain date. I was working to do that. Was not able to achieve that. She gave me another extension. I made that time frame. I served and filed 2 days ahead. Unfortunately, between staffing problems at the Court of Appeal and whatnot, I didn't find out until the Friday that it was missing bookmarks. I completed that by Monday, and I asked for an extension of another day, and I was not granted that. Now, in the order that the consent order that we had signed, I'm sorry, I don't have the exact wording, but it was that my appeal would be dismissed if I did not meet that deadline. And anyway, that was back in December, so they would not grant me another day, so I had to put a motion before a panel, which wasn't heard until May 20th. And I probably didn't prepare my motion properly, but anyway, that was dismissed.
Yeah.
So now my next
so I saw that, and it was dismissed was it on May 22nd that it was dismissed?
Yes, well, the motion I think was on the 20th, and maybe the 22nd that the judgment was written, so I don't want to...
Okay, and so so that's the decision that you're appealing?
That's correct, Your Honor.
Okay, and how do you get the calculation for the deadline you say you now have?
Well, I have 60 days to file an appeal to the Supreme Court of Canada in the month of July. Sorry, I don't know what beeping is. The month of July doesn't count in calculating time. So I have until August 20th.
Okay. Anything else?
I'd just like to say that yes, I am aware of what the cost. I'm sorry, I didn't have the exact figure, but I am aware of the cost order. As I said, I am making my payment for my child support. My lawyer cost was $44,000. I owed him another 20, but we lost so bad that he waived that final. But he's currently in debt $27,282.02. My ability to try to finance this debt before going into high interest rates, and just my ability to do day-to-day banking, is being completely withdrawn from me at this time, which, as you can imagine, is causing a great deal of difficulties. I'm just asking for a stay of this cost order and release of the garnishment so that I can continue with my day-to-day banking in my life while I try to attend to this matter as quickly as possible. Now, I know Ms. will do that this should be adjourned or dismissed as she was on vacation. I received the garnishment order again on Friday, July 8th. It was signed June 24th. As you can imagine, at the end of the month, causing me a great deal of difficulty with my banking, and I do need to get this moving ahead as quickly as possible before a mortgage payment goes into default.
Well, one of the problems you have is that I'm sorry to say, but your leave to appeal to the Supreme Court is almost certain to fail, because you only get leave to appeal to the Supreme Court of Canada if it's an issue of national importance. It's not just about what the merits of your claim might be. I mean, three judges of the Court of Appeal dismissed your ability to pursue the appeal, but regardless of that, the Supreme Court isn't looking at it to say were they right or were they wrong. They are looking primarily to see is it an issue of national importance, which I don't see that there's any chance this would be.
Well, if I can speak to there's two issues here: ownership of our home and custody of our children. Now, in the matter of...
Well, but you're just talking about costs. Your issue right now is just about costs, right?
Yes, Your Honor, that's the only issue I'm here to speak to. I'm not trying to hear the whole appeal today. But in a matter of national importance, I lost custody of my children on no evidence whatsoever besides an affidavit of the applicant, which obviously her and I are in court arguing over the custody of her children. And there is no mention whatsoever in the Children's Aid report that I've ever done anything wrong by my children. There is no mention in any of the police reports that I've ever done anything wrong by my children. So for a matter of national importance, the father is an equal parent and is entitled to equal custody with his children and not be denied of that simply based on allegations of the other partner who herself denies that she has done anything wrong and makes denials about things that are flat out, page after page after page of evidence supporting it, and yet she can sit there and deny. So, there's certainly matters of national importance when it comes to the custody of children and the rights of fathers. Which again, I understand, I'm not here to argue that today. I'm simply asking for a stay order on this garnishment so that I don't go into default on payments, which is certainly not doing anybody any good. It's certainly not going to help the applicant to get any costs or any child support if I cannot conduct simple day-to-day banking and pay a $4.70 American Express bill or anything else because all my accounts have been garnished.
Okay, anything else?
And as for again, I'm not here to argue the appeal, but a great deal of that judgment was based on a fraudulent financial statement sworn by Ms. Amar on March 5th of 2021, where she claims amounts in her financial statement, and I can direct you to that tab if you like. And she puts a note in it where it says paid by Michael. She clearly admits it's paid by me. There's a copy of my check there, and yet she carries that totals she carries those amounts into her totals, and this is the figures that the judge uses. Now, if I can just direct you to the judgment, which is tab 63.
Well, hold on, I don't have any tabs. I don't have I don't know where I would find those tabs. I just have individual documents that were filed.
Okay, I don't know if it's considered tab 63, but it's number 63 at the bottom of the paperwork that's uploaded. The judgment, if you go to page 46 of the judgment.
Okay, so I didn't find the judgment in the material uploaded, but I did find it on King.
Okay, I did upload everything, so I'm not sure.
Okay, what paragraph of the trial decision?
Page 46, the first paragraph.
Do you have the paragraph number?
Let me scroll down to it for a second. That would be 162, paragraph 162.
Okay.
And you see the two children benefit, HST, the cash flow. As set out in financial statements Vivian has filed in this case, including her financial statement sworn on March 5th, 2021, her monthly expenses, inclusive of all household expenses, total $3,975. But if you go to her financial statement, which again I'm not sure if you have, but it's number 49 in my list of material that I have filed. You see Part 2 expenses. Mortgage paid in part by Michael, $1,430.32. Property insurance paid by Michael, $80. Condominium fees paid by Michael, $48.54. But then if you look down, she carries that into her totals, and this is the amount that Madam Justice Kraft uses. And if you also go to number 43 on my list, you'll see the check dated for March of 2021 from me to Ms. Amar in the amount of $1,842.79. So as you can see, it's fraudulent figures that Justice Kraft.
Oh, I don't think that makes it fraudulent.
Well,
I'd have to look at it, but it doesn't make it. That doesn't show fraud. It's possible it shows an error, but I don't think it shows fraud.
Well, okay, like I'll give the benefit of the doubt. I mean, Ms. Amar is represented by counsel. I'm sure that to include amounts and then even to say it paid by the other person, and yet they carry that in your total, and then that is the total that
they
the
said
judge
it was
uses.
paid by someone else.
But then
against it being fraud.
They carry it in the total, though. But
yeah,
anyway,
I
that's what it
understand.
is. Okay.
Yeah.
So anyway, like I say, this case is about ownership of that home and the custody of our two children, and both issues, especially with the Supreme Court of Canada, should have a look at. Now, as for the panel before the Court of Appeal dismissing my appeal, that was not because the appeal is not without merit. That is because that I had signed a consent order agreeing that my appeal would be dismissed by a certain date if I failed to perfect. And again, I did perfect on time the failure of some technical matters and failure of the staff at the Court of Appeal not being in the office due to COVID. I delivered a USB stick 11:30 in the morning. It wasn't looked at for 2 days. Had it been open right then and there and told that, okay, you're missing a technical requirement here, I could have met that and had been on time to file my appeal. So, not to blame somebody else. It's up to me to get on it and get things done in due course. However, I'm self-represented. And, it's not just a case of going to Staples and photocopying pages. I mean, the technical requirements is another world that not all of us have those technical skills, as I'm sure you can imagine. So this appeal is with merit and it needs to be heard. And until then, I would just like a stay order on this garnishment to release my bank so I can just simply conduct day-to-day banking. I have no money to pay for this cost order at this time. And, like I said, I'm $27,000 in debt. And I'm also currently homeless, and I've been homeless since the beginning of May, and doing the best I can to continue on with my life and to see my children and to show up for work on time.
Okay, thank you. Just a moment, please. Sorry, I'm just going to the rules for stay pending appeal. This is the delivery of a notice of appeal. Stays provision for the order of payment of money, but you haven't actually delivered a notice of appeal, or have you?
I hadn't, no, not for the Supreme Court yet, because I'm working on that, and to my best of my knowledge, that it has to all come in kind of one package. I can't just send a one-page notice of appeal.
You just need to deliver a notice of appeal, but anyways, that's what the rule says.
I can have that, by end of day tomorrow. It's just a simple, quick notice that this appeal isn't going to the Court of Appeal. Obviously, I'm trying to prepare my material to the absolute best that I can, so that I don't, stumble on a technical problem again and have failure to have my appeal heard. It is being worked on to the best of my ability.
Okay. Ms. Harris?
Good morning, Your Honor.
Good morning.
As Mr. Smith stated, and as you well knew, I was on holiday when he served his material. He declined to serve my client directly, so we only found out about this motion very late last week, and we weren't able to prepare any material in response or to even let the court know before the confirmation was due. So I wanted to show up here today so we knew that she is aware of it. I sort of have two positions. I'm of two minds. In my view, this is completely meritless for a variety of reasons. And just on the face of the material, we should dismiss the motion. If you feel that you need more information than that, then I'd be seeking an adjournment so that my client has the opportunity to file responding material if she chooses to. I'd like to speak to just a couple of things that Mr. Smith said. First of all, as you noted, he received the garnishment notice on July 8th, pursuant to Rule 29. It's my understanding he has 10 days to file a dispute. I didn't receive a dispute. I received this material. It was in my inbox July 22, so that's not within the 10 days, number one. And number two, I agree with Your Honor, this Supreme Court road is certainly not something that's going to happen. This is not an issue of national importance, obviously. And if you note the last paragraph of what the Court of Appeal said, they said it's very rare. I'm paraphrasing because I don't have the materials. This is my first thing back after 11 days.
Right.
But they said it's very, very rare that a circumstance like this would garner full cost, but we think that this is one of those circumstances.
I mean, I guess the truth is, if the stay pending appeal actually applied, it's not really, I don't think I'm really taking account of the merits of the appeal, because it's just the delivery of a notice of appeal for an interlocutory final order stays until the disposition of the appeal, any provision of the order for the payment of money, except a provision that awards support or enforces the support order. So I guess, I did speak about the unlikelihood of success with the Supreme Court of Canada, but maybe that's not really a consideration.
Absolutely, it's not a consideration. With respect to this stay, Your Honor, I haven't received notice. There's a lot of, I'm going to, I'm self-represented. Mr. Smith is an expert. He's probably been to the Court of Appeal more times than I have, quite frankly. And this is his second appeal to the Supreme Court. He's also appealing the fraudulent order that was made against him with respect to his first wife. Everything's fraudulent, everything's wrong. He just doesn't get the message. I don't think that based on the material before you today, you have the ability to grant Mr. Smith his request. If, however, you think material from my client would help, then we would ask for your indulgence and just set this matter down to be heard at a later date.
Okay, Mr. Smith, do you have anything in reply?
Yes, Your Honor, thank you. First off, I thank you for the compliment, Ms. Harris, but no, I am not an expert in court systems or